So let's talk about something that's really fundamental in the age of instant information. How do you protect your reputation? We're going to dive into a single, pretty fascinating court case that completely changed the rules of the game for free speech and personal reputation here in the UK. And just so we're all clear, we're talking about defamation, specifically libel, which is the written stuff like an article or a post online.
It all really boils down to this one simple but incredibly tricky question. How do you actually prove your reputation is broken? Is it just about hurt feelings, or do you need to show you lost money? What about all the whispers and rumors? For a long time, the legal answer was, well, kind of murky. But one landmark case finally brought it all into focus.
To really get why this one case matters so much, we have to look back at this constant tug-of-war in UK law. For centuries, courts have been trying to balance two huge ideas: an individual's right to protect their good name and the public's right to free speech. For a while, a lot of people felt the scales were tipped way too far in one direction, making it way too easy to sue for libel.
And then, in 2013, everything changed. Before this, if a nasty article was published about you, the courts pretty much just assumed it caused you harm. The bar was pretty low for the person suing. But the 2013 Defamation Act dropped a bombshell of a new rule. Now, you had to actually prove the statement caused serious harm.
And there it is. This one sentence from the new law really did change everything. But look at those two little words, serious harm. Parliament put them in the law, but here's the kicker. They didn't actually define them. They basically built a brand new, super high hurdle in the legal race, but forgot to tell anyone how to jump over it. So this kicked off a huge legal mystery. The law now had this powerful new requirement, but nobody, and I mean nobody, not the lawyers, not the judges, not the journalists, really knew what serious harm meant in the real world. It was just this massive gray area waiting for someone to define it.
And that raised the all-important question: what kind of proof would a court actually need to see? Do you have to prove you lost your job over it? That your friend stopped talking to you? This abstract legal idea was just crying out for a real-life case to come along and give it some solid meaning.
And that test case? Well, it arrived in the form of a lawsuit from a man named Bruno Lakshaw. His incredibly personal and very public battle to clear his name would go all the way to the UK's highest court. And in doing so, his case would end up setting the standard for literally everyone else.
So the case was all about a series of articles published by some major UK newspapers. They contained some extremely serious and damaging allegations about Mr. Lashaw's private life, particularly his conduct during a pretty tough divorce. And crucially, these weren't some obscure blog posts, right? They were read by hundreds of thousands of people. The potential for damage to his reputation was absolutely immense. So after years of legal battles in the lower courts, the case finally landed in the UK Supreme Court. You can bet the entire legal world and all of the media were watching. This was it. This was the moment they would finally get a definitive answer to that serious harm question.
The court came up with this really clear three-part logic. First, they said proving serious harm is now the new starting line. It's the absolute first hurdle you have to clear. Second, you have to show the receipts. You can't just say you were harmed. You need to bring actual evidence. So what's that look like? Well, it could be emails showing a business deal collapsing right after an article came out, or maybe testimony from people who say you were suddenly shunned at work. And third, the harm has to be about real-world impact, how other people actually see you, not just your own hurt feelings.
And just like that, this case created what everyone now calls the Lakshaw test. It's the simple but powerful principle that if you want to win a libel case, you have to prove with cold, hard facts that what was published caused real, serious damage to your reputation. The days of just assuming harm were officially over.
Okay, so the mystery is solved, but what does this all mean for the rest of us? Well, this decision created a completely new reality for anyone involved in a defamation fight, whether you're a journalist, a publisher, or just an ordinary person online.
You can see the new balance pretty clearly. For the people bringing the claim, the burden of proof is way higher now, making it a lot harder to sue for libel. The whole point is to weed out the more minor or frivolous lawsuits. On the other side, for publishers and journalists, this offers much stronger protection. It gives them more freedom to report on important stuff without the constant fear of being dragged into court over claims that just don't meet that very high serious harm bar. And hey, for any of you who want to go down the legal rabbit hole and read the judgment for yourself, the official case citation is right there.
Which, of course, leaves us with one last big question. This landmark case drew a new line in the sand. It was meant to create a modern, fair balance between protecting a person's name and protecting free speech.
But did they get it right? Has it actually made public conversation healthier? Or has it maybe left some people with real damage to their name without a good way to fight back? That's the debate that's still going on today.